SJC 13153 in the matter of an impounded case.
Okay, Attorney Kurian. Oh, you're on mute.
Apologize for that. Good morning, Chief Justice and Justices of the Court. My name is Pauline Kurian, and I represent the appellant in this matter. This case presents the question of whether the trial court abused its discretion in denying expungement of the appellant's decriminalized marijuana charges and in finding that expungement was not in the best interest of justice under Section 100K of Chapter 276. Simply put, this is a case where things went terribly wrong as to the judge's interpretation and application of the expungement law in several ways. First, while a judge has discretion in applying the law, that discretion is not without limits. Here, the judge's denial of the petition was against the weight of the evidence and the arguments made below, which were all in favor of expungement. Nothing was said or presented below or even hinted to the possibility that there would be a benefit that would flow from preserving the record, or that preserving the record would advance the interest of justice. In fact, the petitioner's attorney explained to the judge that records would be destroyed if they were expunged, and there was no opposition from the assistant district attorney in the courtroom. And upon the reconsideration motion, the district attorney's office filed an assent to the expungement, specifically stating that it was unjust to maintain the record when the underlying offenses were no longer a crime. Second, the judge's written findings of fact also fell short and reflected a misinterpretation of the law. The judge's findings denying the expungement only found that destruction of the records was not in the interest of justice. Rather than weighing the facts of the circumstances of the arguments presented at the hearing on reconsideration, the judge used the fact that an order granting expungement of records results in destruction or erasure of records as a basis all by itself for a finding.
Can I ask a question about this? This involves an intersection of convictions for marijuana with other offenses, right? The marijuana offense obviously is no longer an offense, but the others are. He gave a false name to the police. He's driving with a suspended license. And then the judge uses this term: the court does not find that it is in the interest of justice to destroy. He adds the word all records relating to these charges. I'm just wondering, is the fact that we've got an intersection of criminal behavior here matter? Because, I mean, it's not as if the judge just had a marijuana offense, the 2003 one, for example, and he refused to expunge that one, but rather there's sort of an integration of criminal offenses here.
No, that shouldn't affect whether a petitioner is entitled to relief. I mean, the legislature specifically carved out 6 categories of situations where someone could expunge a record, including decriminalized offenses. It didn't say, and if you've got other cases on your record, you can't expunge.
Well, by removing the marijuana, I'm not disagreeing with you necessarily, but it just seems to me it's different, because when you remove the marijuana offense from the incident, it changes it changes it in some respect. You got a full picture of what was going on here. So I'm just trying to understand, does that give the judge some discretion that you have to address?
Well, I think there are 2 points that can be made that I think would resolve that issue. Number one, the expungement statute doesn't just provide for destroying records; it also provides for erasure of records. So what can happen is they can simply erase or redact the expunged offense from the records, which would leave the other offenses intact. And then in response to the issue of the other offenses that were on his record, it's relevant here that in this situation, the petitioner had sealed all of his records. So under the statute, these other offenses, they technically speaking, because they were sealed, in some courts, what they'll do is they'll put a piece of paper covering it up, in terms of this to block it out. But in this instance, they were sealed, so they weren't relevant to the proceeding. And Section 100A of Chapter 276 specifically says that sealed records are not admissible at a later hearing unless it's on a subsequent offense at the time of sentencing. And then there's also a special exception if you're in the probate and family court or in the 209A proceeding. The district attorney or counsel for a plaintiff could file a motion to get access to the record. And then there's an in-camera review and a determination of relevancy. And there's a whole other proceeding. But the fact that there may have been other things on his record is not an impediment to expunging his records.
I know it's not an impediment, but it's an abuse of discretion standard we're dealing with, and it complicates the analysis. I'm not saying it prevents him or her from doing that, but we have to find it's an abuse of discretion, which is different.
Well, I think
Counsel, before you answer Justice Caffrey, can I piggyback off of that? Are we hampered here by not? I don't believe the carry is in the record here. Am I right about that?
Well, what happens is when there's a court proceeding, they tend to destroy the carry. But what the facts of the case were that
No. In our record appendix, because the reason why I'm asking that is to Justice Kafker's point. You made the point about erasure. If I remember the pleadings correctly, you're relying on another statute for that, right? Where there's co-defendants. In that they could redact parts of the order that had to do with just the petitioner, but not the other co-defendants. That's not actually in this statute, right?
The statute is silent on erasure, but I think in applying the statute, common sense is going to apply, and specifically, the section 100A prohibits the use of other offenses in any kind of proceeding, basically, other than a subsequent sentencing event that happens after a subsequent conviction. So in this instance, I don't think that that should be a reason for denying the petition. And as I started to say,
let me finish my point, because although it might be a qualifying reason for expungement that this crime has now been decriminalized, the statute also then gives the judge the discretion to deny the petition if it's not in the judge's considered judgment in the interest of justice. So to the extent that the petitioner is saying, I'm suffering all of these harms, and the judge has in front of them a carry that shows all of these other crimes that are not sealed or not expunged, that detract from that, right? That the idea here is that there are still going to be these same kind of considerations that you might be suffering if you've got all of these other charges that are in front of the judge that we don't know. The record doesn't seem to indicate whether we know that or not.
Well, I mean, there are several ways to run a carry, and in a sealing or even an expungement situation, the carry that's run shouldn't be reflecting cases that are sealed, because those are barred from consideration under Section 100A.
Right.
So
I'm saying we don't know what's in front of the judge. So isn't the remand the proper disposition here?
Well, I don't actually think I think everything is on the record, and it's basically documentary evidence. So this court actually could address the problem. But more importantly, I would hope that this court would clarify the best interest of justice standard, which is not defined in the statute. And here, what happened was The judge just found that there was a destruction of the records that was not in the interest of justice, rather than weighing the facts or the circumstances of the arguments that were presented. And then the judge used the fact that an order granting expungement results in destruction of the records as a basis all by itself for finding that expungement was not in the best interest of justice. This was essentially an objection to the very purpose of the statute, which precisely provides for expungement rather than a weighing of the specific facts and considerations for or against expungement of the record. So I would hope at a minimum that this court would clarify that the fact that records may be destroyed or erased as a result of expungement, that in and of itself is not a reason for denying expungement. And in this case, there was ample evidence in favor of expungement in this situation. The cases were old, that the petitioner had been denied employment. And fundamentally, if you think about Section 100K, the interest of justice by necessity implies that there has to be some fairness in maintaining the record that advances or promotes the interests of justice. And as the district attorney indicated in his assent, and her assent rather, there is an inherent unfairness in maintaining a record when the underlying offense has been is no longer a crime. And in this instance, if you look at all the categories under Section 100K, it's also important to realize the legislature said that you don't even have to have a hearing. So it was anticipated these cases would be simple enough that they would be done on the papers. And I think it's important that in terms of a judge hearing a case, they have to weigh the advantages and disadvantages of either maintaining the records or expunging the records, and then also the effects on the particular petitioner. And I think in particular, what was raised at the argument was the race implication involved in the case, because if your police now have access to quarry in their cruisers, and there is a problem in society with Black people in particular being stopped by the police. So he had articulated that concern. So to some extent, expungement can be used as a way to mitigate racism and a lot of the problems that people encounter in terms of police stops. And the other thing for this court to consider is the effect of denying the expungement, which not only is inconsistent with the purpose of the statute, but if you want to, if you're unemployed, like the petitioner in this case, you want to apply for lots of jobs and you're going to be foreclosed from federal employment. And if you get your expungement petition allowed, then the order is sent to the FBI asking them to also expunge their records. And there's no federal law that allows you to seal or expunge records. So there are many benefits.
So give me an example of what you would consider best interest of justice in keeping a record, or are you just saying that every one of these things should be expunged regardless? Give me an example. You want us to define best interest. Give me one where you find one where it should be preserved.
Well, I think this is exactly the case where it shouldn't be preserved. Try my question just once. Give me an example where it would work against the view that every expungement should be allowed. Well, it's every case is going to be grounded in a particular facts. I think you're hard pressed when you have a situation involving decriminalized records to say it's not in the interest of justice to expunge. But there might be a situation, for example, if somebody were a fugitive from justice, or if in the course of the proceedings the person had an outburst because they were impatient and it took a long time to call their case. I mean, there may be factual circumstances, but they certainly don't exist in this case. So it's a little hard to speculate, in particular because the offense itself is decriminalized. And as the district attorney's office pointed out, there's no utility to these cases Because the
You want-
offense.
You want us to define best interest? Give me a definition of best interest that is applicable then.
Well, I think first off, I think with the definition of the best interest, the court should first look at the fairness of maintaining the record versus the fairness of granting the expungement. So one of the big questions is, does maintaining the record advance or promote the interests of justice? And the same with expungement. Does it promote or advance the interests of justice? So here, in terms of decriminalized offenses or the other categories under Section 100K, these are all basically innocent people or people who shouldn't have been prosecuted. And then you have the instance where the offense itself is decriminalized. So I think the first prong of the test would be the fairness of maintaining the record versus expunging it. And then the benefits and the disadvantages related to maintaining the records versus expunging them. And I think it's not that I'm trying to evade your question. It's just I'm hard pressed to come up with any reason why one would maintain, a decriminalized offense because it has really no utility. And then I think the other important thing for the court to also consider is the whole body of law. The legislature has gone to great extents to give people second chances. And as this court articulated in the pawn case, any case or criminal charge, regardless of what it contains, it can be an impediment to housing and also employment. And the court also said there's a compelling interest on behalf of the Commonwealth that people be reintegrated in society and get jobs. So expungement deals with the unfairness of the situation on its face when you have an offense that was decriminalized, but also
I'm gonna say that your time is up, yeah. And we'll go ahead and go to Attorney Doherty.
thank you.
Thank you.
Chief Justice Budd, and may it please the court, Andrew Doherty for the Commonwealth. I'm a little unclear how many of these cases the court has reviewed, so I may start with very general principles first, and in defining what the best interest of justice standard is. I think the best place to look is the Boston Police Commissioner case of 1978, where Justice Liakos describes the two interests at stake when a juvenile looks to expunge police records. Now, there's significant differences between that case and a statutory scheme that describes expungement, but the interest that Justice Liakos describes seems very relevant to the question of whether expungement is in the best interest of justice. So my first principle starts there. The second general theme that I'd ask the court to adopt when defining what the best interest
Mr.
of
Doherty,
justice is.
why don't you remind us what those two interests were that Justice Liakos described?
The first is what harm might befall the petitioner as a result of the existence of this record. And we'll be able to talk about some of the questions that both you and Justice George has asked when I sort of get to that point. But the second point is, what is the utility to the public interest caused by the ongoing maintenance and access to these records?
Okay, so let me take those two interests. And again, it becomes more complicated when we have someone with another record and the other record arises out of the same offense, the same incident, right? The 203 one is a separate one, but the second one, the giving the false name, the driving with the suspended license, it's all the same event where they detect the marijuana, right?
It is, and
could you just apply then Justice Liakos's two? So what's the interest? What harm might befall the petitioner? So here we've got a petitioner with a record already. He has another record. So do we measure the harm in terms of someone without a record versus a record, or is that a different inquiry?
So there's a couple questions. I mean, I think we should start with the fact that I think it's ambiguous that you could divorce the two criminal cases when there's a mixture within a docket, right? Because this court record as a whole has both expungible and non-expungible offenses described in there. So there is some ambiguity that I described in my brief about the conflict there. But secondarily, I think when the district attorney, and this gets to when we talk about the utility of that record, when the district attorney assents to a petition, as it did in this case, or even doesn't object, what we are saying is this record has no utility to the public interest. And
Well, I mean, with all due respect, if we had a different DA's office, they might be arguing this differently. So I'm a little confused how far we go with that.
And I don't want to jump ahead, but I think that is an interesting question. But I also think with many of these cases, it's going to be hard pressed to come up with a basis for why an objection is warranted in many of these cases. Certainly in cases, several of the
agree. I'd be both confused about coming up with a justification to preserve a 2003 marijuana possession alone. I get it, but this is a little harder than that. Lying, giving a false name to a cop, driving with a suspended license, those are more serious offenses, and they're integrated here with the marijuana.
I agree with you, and I would also say that those offenses are not eligible, and the court records and Corey records and probation records are not eligible for expungement for those offenses. But I do think that the marijuana offense in that mixture of charges is an expungible event. Now, would that mean that
I totally agree that it's an expungible event, but we're analyzing an abuse of discretion standard, right? It's I'm not sure I would have done what the judge did, but that's not the standard we're dealing with.
I would also just add, and only because I'm also handling a separate appeal with this judge where the basis for his refusal was that police records and district attorney records were going to be expunged. This is before the appeals court. So I don't know that by the judge saying all records are going to be destroyed, and that's why he has a problem, that he wasn't referring to the fact that he believes, I think incorrectly, that Boston Police Department records and district attorney's records are going to be destroyed. So there is some question about that. If this was remanded and he said, I don't want to get rid of the reckless driving, I would agree that that is not something that should be and expunged, and that we could then go back to how best to resolve the ambiguity in the statute about whether or not he can redact the portions of the complaint and not destroy the entirety of the court record, which contains expungible events.
Attorney Doherty, can I go back to the question I asked Attorney Quirion? Do we have enough to be able to assess what was in front of the judge here? Because let me give you an example. Again, I didn't see the carry in the appendix, and perhaps I just missed it, but let's say between these two events, there's a 2003, and when was the latest one?
2006.
Okay, let's say between 2006 and when the petition was prosecuted, there were all of these other charges that we don't know anything about, that the judge, when he's presented with the petition, gets the carry. And I'm not even talking about the stuff that was sealed. Maybe there were other things that were not sealed that were in front of the judge. And on the one hand, you have a petitioner saying, I have all of the to use one of Justice Gaziano's phrases, the parade of horribles that are going to befall him if the court doesn't allow this petition. But the judge is looking at it and saying, but there's a litany of other charges between 2006 and now that are still on your record, that are not sealed, that are not expungible, that are not eligible for expungement. And the judge then goes to the interest of justice and say, you haven't met your burden, because even though it's presumably a charge that can be expunged, it's not in the best interest because all of these other things are still there. So again, do we have enough here to say that the judge abused his discretion?
I think you do, because I think no matter what's on his query, any individual charge is going to have with it some cloud of prosecution. However weighty that cloud may be, that is something that falls in the defendant's side. And I think here, if he had 100 charges on his record, there is at least some grain of weight to the cloud of prosecution that's associated with any criminal record. Now, would that outweigh the slightest bit of utility to that record? I don't know that it would, but here where there is no utility to the record, that should fall in favor of expungement for this defendant. I do think the query is certainly relevant, and in terms of weighing the defendant's harm from that cloud of prosecution, but it's relevant, but it doesn't. I can't see that it
the direct
utterly makes it.
The direct question is abuse of discretion, and I think what we're asking you and what we're hampered by, in we don't have anybody on the other side. The judge is in the party here. Okay, so let me give you a hypothetical. So this judge has the carry in front of him and sees that there's 3 B&Es on the record, a trespass, and a stolen motor vehicle, and all the weed cases that are subject to expungement. And the judge may say, well, what difference does it make? This is rearranging the deck chairs on the Titanic. The guy's not going to get a job anyway because he's got all the B&E cases. Is that an example where it wouldn't be an abuse of discretion? And I get the judge probably, if that were the case, the judge probably should have made findings that said that. But would that be an abuse of discretion?
So I would say, if there was something to weigh against the defendant, the harm to the petitioner, yes, I don't think it would be an abuse of discretion if that had diminished the harm to the petitioner.
Right, because the other offenses would be an impediment to gainful employment as well.
Well, I don't think respectfully, I don't think any sealed offenses are an impediment to most forms of employment. No,
I'm talking about my hypothetical where the carry would show other criminal offenses that and I think that's what Justice George has been asking.
Oh, sure. Right. I mean, I think that if the sole basis for a petitioner's expungement claim is this cloud of prosecution, a significant carry is going to diminish the weight of that harm, but I don't know that it erases it. And if there's nothing to balance against it, I don't know that it. Well, I don't think that it's.
What I don't understand is that and I get the that the section 2, the subsection was probably geared more towards these marijuana cases, right? These antiquated cases matters that are decriminalized. But we still have within the same legislation an abuse of discretion, interest of justice overlay. So if this was self-executing, they'd be self-executing. And I know you're. I know certainly said that they probably shouldn't have hearings on these things, and maybe you're right, but the judge still has a role in this, right?
Yeah, I want to be very clear. I do not think these are self-executing. I think that the only presumption that I would put on the table here is that a criminal record creates a cloud of prosecution.
And I don't think counsel is arguing the self-execute. I think we may want them to be, but the statute doesn't make them self-executing, right?
Absolutely not. And unfortunately, it hasn't quite defined what balance it needs to be made in the best interest of justice. And so I suppose when in considering those two things, it's the use to the state versus the use the harm to the defendant.
And I think this is why you both brought a very valuable case to allow us to articulate what that standard is.
Yeah, and let me follow up on that point, Justice Gaziano, and ask Attorney Doherty, do we have everything in our record that the motion judge had before him?
I do not know if he had the defendant's board of probation record.
He would absolutely have had that. he absolutely would have had it.
Right.
Absolutely.
So it is not part of the record. You know, I understand the court's concern. You know, in thinking about this, and it just sort of came to me, if a decriminalized offense had a history of defaults on the record, where for 2 years the defendant was in default, where there was multiple defaults, probation violations, even though it's a decriminalized record, I can certainly see that being something that would be of use to not just the court, but the Commonwealth in considering bail conditions for a defendant or something else. I think that that is a interest that would certainly be something that would work against expungement, because it wouldn't just erase the record of the criminal record, but also a history of default. So that's one thing that I think the CORI would have reflected if there was any. There's one other. I'm just trying to think. Oh, one other caveat I would just ask the court, if in thinking about the best interest of justice, is to be very clear that there is a very large distinction between sealing and expungement, and that expungement, which is an extreme remedy, in that it is the utter and permanent destruction of a record, it is irrevocable. And there is a very limited group of a limited amount of harm that is caused to a petitioner. It's not related to most forms of employment. It is only related to law enforcement and those things, gun licensure, as well as the care and protection of children, all of which are extraordinarily compelling public interests. But all others are forbidden from looking at this record. So in weighing both the petitioner's interest and the public interest, just ask the court to make clear that that's how a judge should be looking at this. In the 15 seconds I've left, I just wanted to point out another ambiguity I think is problematic and is a part of the record, and the court may wish to consider, which is because I think because of the way the sealing statutes work, this petitioner had to unseal his record in order to seek an expungement. That seems to me to be very much at odds with the intent of the legislature, and whether it's inadvertent or not, there is a significant problem I see where a petitioner has needs to make public a record that he is seeking to make private, and I believe that is an interplay between the sealing statutes A, B, and C, and the effect of that, and the fact that that's not addressed in the 2018 legislature. So I just ask the court to consider that if it can. It is reflected in the record, and I think as well in the defendant's brief.